Good morning. This is Rich Sierra, President of the Florida Small Business Legal Center. I'm here today with Angela Neave. It's my first guest for the SOS podcast. I'm very excited. Welcome, Angela.
Thank you for having me.
Today we're going to talk about different subjects, but first I want to talk about Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. The book is available on Amazon, Barnes & Noble, and ask for it at local bookstores. Before I talk, I'd like to introduce Angela first. Angela is a divorce attorney. She's the owner of Neave Family Law here in Fort Lauderdale, Florida. Angela first experienced divorce as a child and later as a parent who earned full custody of her daughter. Understanding how legal issues impacted the direction of her life, Angela switched careers and dedicated herself to family law. As a full-time single parent, Angela undertook an intensive 5-year program in which she earned a philosophy degree from UCLA and a Juris Doctor degree from Southwestern University School of Law. She moved to South Florida and then, guided by client-centered philosophy, opened Neave Family Law. Angela balances her work ethic and capacity for mastering complex legal work with large measures of empathy and respect. Angela is a skilled trial lawyer who has litigated all varieties of family law issues. She thrives in the courtroom, where she has earned a reputation for tenacious representation. Angela specializes in high conflict resolution, custody cases, and complex property division matters. Welcome to the show.
Thank you. I sound so important.
And you are. I'm very excited that you're my first guest. Today we're going to talk about, it's not a pleasant subject, divorce, but it happens.
It does.
So we're going to talk in the concept of what happens to a business, how a business is affected when there's a divorce proceeding taking place. And as we know, there are many small businesses that are owned by husband and wife.
Yep.
They're owned by partners. So it is very common that when there is a divorce proceeding, usually the business kind of gets involved. Can you tell us a little bit more about that?
Yes. So depending on the type of business, oftentimes if I am an attorney on a case where one of the parties is a business owner or both of them, the business can be and oftentimes is added as a party to the divorce action. So that's number one, getting the business served, and whoever is the registered agent will accept service with regard to the divorce paperwork for the business, and then the business might have to comply with some discovery requests. So that's the first step that typically happens if there is a divorce where there is a business involved.
And why is the business also added to the lawsuit?
That's a really great question. Oftentimes the business is added because if it's owned by the husband and wife, or if both parties are working in the business and the business is going to be split in some fashion, without joining the business, the court may not be able to order the business to do specific things. So that just gives the court an ability to say the business must produce these documents, or I'm going to give all of the stocks for the business, or all, depending on the entity in which the business is owned, to one or both parties. So that just allows the court to have direct access and contact with the business.
And what would be the business obligation in this case in the divorce proceeding?
Well, the business is obligated to comply with discovery requests. If there is a hearing in which the business interest is being represented, they would want to show up with perhaps counsel. Oftentimes, one party in the business is trying to protect the business and another party is trying to expose the business. So typically the one party trying to protect the business will take the reins on that. But it's always great for the business to have their own attorney that represents the interest of the business, because sometimes what's best for the business is not necessarily what's best for either of the spouses.
So what are some of the mistakes that sometimes business owners make when faced with a divorce proceeding?
Oh, there's so many. I can think of one really important one, and that is don't suddenly change how you operate the finances of the business, because you can't really hide it. If you were running all of your expenses through the business, let's say, prior to a divorce, and then a divorce is happening, don't suddenly shift and say, oh, I make 50% less, or I only make this small amount of money, because in the discovery process, the parties are going to be able to access and get the books, the bank account statements, and have a look and see how did money traditionally flow through this business, and you're not going to be able to hide whatever income or whatever business money you were using to pay personal expenses.
I recently received a call from a client, actually out of state, and we had some type of interest in Florida, in which basically they husband and wife owned the business together, and she basically was trying to get him out of the bank account and transfer money to her personal account. I think it's not a good idea, but have you experienced something like that, and what would you advise somebody who's thinking about doing something like that?
So that is always very tricky. This issue comes up often, especially when one spouse thinks that the other might drain the account, or if that spouse is in fact taking money. Obviously, transferring money from a business account into a personal account creates a taxable event, so you want to look at that. Is this person now taking that money as income, and do they have to declare that on their taxes? So that's one thing to think about, and maybe a reason not to do it. But businesses need money to operate. So you don't necessarily want to remove the money from the business account and prevent it from continuing to operate, because you don't want to kill the goose that's laid the golden egg. And if this is the business that the parties have been supported by for their entire relationship, and maybe before they married, you don't want to remove the money from the business and prevent operations. And that happens often in a divorce, where suddenly the business is in a position where the parties are taking more money out of the business than they traditionally did. And the business is robbing Peter to pay Paul in order to continue operating and paying the salaries of maybe their employees, to try and float the cost of the divorce expense, because oftentimes that is paid by the business. So I don't recommend it unless it's absolutely necessary.
I'd like to do first of all, disclaimer that what we're talking here are basically concepts, and this does not apply to your particular situation.
That's absolutely correct.
If by chance you are in this situation, certainly recommend you contact an attorney. But we're talking basically general concepts, and does not constitute legal advice. So having said that disclaimer, what are the consequences to, say, for example, in this case, the wife actually successful on taking the money out of the account, locking the husband out of the bank account? What are the consequences to, in this case, the wife? What could be the consequences also to the business if this goes in front of the court?
So let me start with consequences too. In this fact pattern, the wife taking money out of a business account or locking her spouse out of the account so he can't access for operations that cash. What happens in the divorce arena is that the court can look at that and say, oh, she took out $100,000. We'll put that on her side of the table, and whatever equitable distribution she's receiving, or maybe even alimony, will be reduced by that number, since she's only entitled to half of that. So let's break that down for 1 second. If she took $100,000 out of a business account, ideally $50,000 is hers and $50,000 is her spouse's. And if she really wanted to take money, she should have only taken half. That doesn't even address whether or not that money should come out of the business account to affect operations, but the court will put that money on her side of the table at the end of the day and say, well, you already took it. We're going to give that to you, and then you're going to make him or her whole on the other side with some other assets. So that is one effect of doing that. The effect it could have on the business, if it doesn't affect operations, is that now the business is worth less. So if you're valuing the business for purposes of distributing it in a divorce, the less cash in the accounts actually reduces the value of the business, which reduces the value of the buyout. So maybe that's an unintended consequence of the action of the wife who stole $100,000. Now she's actually devalued the business in some fashion, and perhaps will get a lesser amount on her value of the business. So I don't recommend it. It doesn't ever help.
It doesn't end well. One thing that would it be possible in this case that the judge say, you know what, I will appoint a receiver.
Of course it's possible.
Can you talk to us about what is a receiver and what would happen in this case?
So the receiver is somebody who comes in and essentially takes over running the business. And instead of the parties who are going through the divorce action making the business decisions, the receiver steps in, pays the bills, is in charge of protecting operations and essentially making sure that the business stays afloat. And unfortunately, when a receiver is appointed, sometimes that means that the business is either going under, could be based upon one of the parties' actions. Typically, a divorce is precipitated by some event. It could be a substance abuse problem. It could be a gambling problem. There's lots of reasons why a business could need a receiver. But in the divorce action, the receiver is essentially there to protect the best interests of the business and keep it operating.
My understanding of a receiver, and I've, drafted orders for a receiver, they have a tremendous amount of power. And I get the analogy that I can give, and I've talked to some of the clients in business partnership disputes as well, that the receiver becomes the de facto owner of this company. And they'll have the ability to go into the bank accounts. They actually take over the bank accounts. They take over, they're the ones that write the checks.
That's correct. They do. They become the de facto owner and decision maker for that company. And when that happens, if the parties, and I'm going to give an example, let's say they were able to take $25,000 every single month from the business, and that's what they paid themselves and lived off of. The receiver comes in and may look at it and say, we're not giving you $25,000 per month. We're giving you $15,000 per month because we need to keep the rest of that money in the business to operate it, pay expenses, perhaps pay a tax liability, perhaps pay penalties. There's all kinds of things that go on, and the receiver is in charge of balancing the needs of the family with the needs of the business, with, say, an issue if the IRS is involved or if the SEC is involved, depending on, the trouble the business may be having.
But also the receiver can be a double-edged sword. I've had clients say, you know what, I want to appoint a receiver to the business. I'd rather the receiver take it over. And I'm like, not so fast. So the first thing...
Good advice.
let's talk about this for a second.
Yes.
So the first thing that I do, I have a blank order or receiver that I drafted. I remove all the information. I said, I want you to take a look at this and we'll talk about it. And it's a really 2 or 3 page order that basically gives so much power to the receiver. But also say, listen, what's going to happen here is that the receiver is going to hire a separate law firm to represent the company.
That's correct.
So, and that means the receiver also now has, and then it's going to hire a forensic accountant to audit the company.
That's correct.
So if by any chance you took any distributions that the receiver does not agree with, the receiver has the ability to sue you to get the money back into the company, your company that you actually started.
Correct.
So, when people say, I'd rather have a receiver run, and I say, let's talk about this, let's pause, because the consequences to you, it is like basically the analogy that I can give you, basically, you adopt a dog and you basically, play with this dog begins to attack you now. So it's like, what happened here? And you have no way to control it. And the only way the receiver can be removed is by the court order.
Correct. Dissolving the order, appointing the receiver. That's correct.
And I have situations where, in a business setup, there's a couple that, own a business together. They wanted the receiver, they agreed to it, and then when the receiver began to look at the finances, he said, listen, I don't know they want me to continue, but if I continue, I might have to sue them for unlawful distributions. So clearly that got resolved very quickly.
Yes.
So maybe this is not a good idea.
Yes, if there are business owners who are in a position where one of them is saying, let's appoint a receiver because they feel like they can't continue running the business together. For example, one says, we need to take out a loan, we need to make a capital investment, or we need to buy new equipment, and the other objects and won't sign loan paperwork, and they're not getting along and they can't make the business decisions together, one might suggest a receiver, and I would say to the one that's suggesting the receiver that they really take a good long look at whether or not they can continue operating together, because a receiver means they lose control.
Yes, and so if anybody's in that situation, please consult your attorney. This is very, very important. Some things that I run into is like in especially in small businesses, say the husband has the business, say, for the last 10 years, they're running it, but the wife is not involved. Mm-hmm. And all of a sudden, there's a divorce proceeding, there's a divorce filing, and, I get a call, well, she doesn't own the business, mm-hmm. I own it. Mm-hmm. Can you please clarify, in reference to, in Florida, for example, what is the business? Is the business something that is part of the marital property or not? Or somebody say, I own the business. Who really owns the business here?
Right. Well, It depends. Famous lawyer answer. So if the parties, if say the husband in this circumstance opened the business during the marriage, it is considered a marital asset. He may in fact hold all the shares or own all the stock or be the managing member if it's an LLC of some sort, but it is still a marital asset that will be divided. So then the court is going to look at what kind of a business is it and then look to put a value on that business. So likely he will retain the business. He's not going to have to give it up or sell it, but he may have to buy her out. So she may have some equity or monetary interest in that business. If, however, he owned that business before they got married, it is a non-marital business, and there may be a marital component that he'll have to buy her out of, depending on whether or not there was a prenuptial agreement involved that segregated that asset as a separate non-marital asset and segregated his income as separate non-marital income, because income earned during the marriage is considered marital unless there's a prenuptial or postnuptial agreement that designates income as a non-marital asset. And any money that you earn from the business that you put back into the business commingles that asset. So even if it's a premarital asset, a marital component could be involved depending on how the business is grown, whether money is put back in, whether or not there's a prenup. But the owner who owns it will remain the owner, especially if the spouse does not operate the business, doesn't participate. That does not change. He may just owe her some money at the end of the day.
You just mentioned prenuptial and postnuptial agreements. Can you tell us a little bit more about that?
So in the context of a business, I find that they are great contracts and tools for everyone to understand their expectations going into the marriage about finances and ownership interests. So typically a prenuptial or a postnuptial agreement, which is just a prenup entered into after the parties are married, they would protect the asset and essentially state this is one of the business is one of their premarital assets, and any income that they earn will be non-marital, meaning it doesn't go into the marital pot, which allows the business owner to reinvest in their business without commingling and creating an asset. It essentially protects the asset from the spouse in the event of a divorce.
Are there any other than the prenuptial, postnuptial agreements, any other mechanism that business owners can do to protect their businesses in the event of divorce?
Well, I would say, first of all, have your operating agreements, right? Don't go into business with somebody without any operating agreement, because that will talk about what happens, how do people get paid, who owns what percentage interest, and what happens if you have to dissolve the business. And that's just good business dealings. I believe you addressed that in your wonderful book. But
Thank you.
In particular with the divorce, the operating agreement essentially tells everybody in the divorce how the money is supposed to be shared and who is supposed to get what, so that there's no guessing as to, is this partner earning 50%, 75%, 35%? Maybe they only have a 2% interest, in which case their interest is nominal. You don't want to waste a bunch of money looking into that business if they are not a main owner.
There are some situations in which, say, you have a business and then you have, say, two partners. And then one of the partners is the one going through a divorce. The other partner really has nothing to do with it. Mm-hmm. How does this affect the other partner?
In so many ways. Emotionally, because typically when people go through a divorce, it's a very emotional process. And I'm going to suggest that 90% of that person's energy is occupied by the divorce. And so that leaves 10% of that person's energy to be a business owner, be a spouse, be a parent, be a friend. So a lot of their energy is wrapped up in the divorce, and that's just what happens. It's you can't avoid it. A divorce is one of the main stressors that a person can go through in their life, and it should occupy their time. They should be devoting their time to it, processing it, moving through it, and then moving on. But that partner may not be able to devote all of their attention to work. So if they're the business development component of that business, they may need help. We might want to consider hiring somebody to come in and do business development with them so that they can pick up slack. Part of another way that the business can be impacted is discovery. So the spouse may be asking for business books and records, but they also have been known to ask for the partner's personal information, books and records. And the business or the partner may need to hire counsel to represent them on these discovery issues to either say, I don't have to give up my personal bank account statements, it's none of your business. And typically judges don't do that. But judges might allow business bank statements to be produced in connection with the dissolution.
From what I've learned is that the family court judges have a tremendous amount of power.
Yes, they do.
Can you expand a little bit more on that?
Yes, never give your power away. As a business owner, you want to retain that as much as possible, so that it applies to receivers, that applies to divorces, that applies to asking a judge to make a decision for you. The judge is bound by the statutes, rules, and case law of Florida, so they cannot be as creative as two spouses may be and their attorneys in hoping to resolve a divorce or to divide assets. So I would say it's never recommended that you go before a judge and have a judge make any decision, because a judge is going to make a decision based upon the information that's put in front of him or her. They don't have the business best interest. They don't have either spouse's best interest. They are going to look at it and say, what makes sense in accordance with the law based upon the information I'm given? So at any given moment, if the judge doesn't like your attorney, or if the judge doesn't like the way you look, or you remind them of their ex-spouse or anything like that, you're making a gamble with your livelihood, your business, your baby that you may have grown for years. And so, yes, the judges do have wide discretion. They are limited by Florida law, rules and statutes. And you definitely, in that instance, want to have an attorney that is on the ball and working to protect the business in addition to your interests in your divorce.
I've had situations in which sometimes clients show up. Now we're doing things via Zoom, and especially in cases that are not involved with jury trial. And in prior episodes that I talked to about litigation, 80% of litigation at the beginning is procedure and process and discovery.
Yep.
And the facts are like 20% if you make it to trial. But at times, divorce and any type of partnership dispute is very emotional. And sometimes the clients show up in a Zoom call and antagonize the judge.
Yes.
That's not a good idea. Why?
Well, the judges are put in the position of having to make a decision because you and your spouse or you and your business partner have been unable to make those decisions together. Right? So this is sort of the judge is the backstop. We have to do this. I have to make a decision. So when a party gets on a Zoom call or even in person, antagonizing the judge can take a lot of different forms. It can be talking when it's not your turn to talk. It can be saying things that are inappropriate. It can be saying something like, well, I don't agree with your decision and I'm going to appeal you. There's so many things that someone can say to a judge that antagonizes them. It really just doesn't set you up for future good experiences in court. And if you really antagonize a judge and you're really disruptive to the process, the judge can have you removed. And on Zoom, it's as simple as kicking you out of the room, and then you're not in your proceeding at all, and you're not participating, and you don't know what's going on. So you definitely do not want to find yourself in a position of antagonizing a judge.
That is true. And also, it just clouds the whole process. And again, the people are humans, people get emotional, especially by the time you go to court. That means that you cannot solve the problem yourself with your partner or your spouse or a business partner.
That's correct.
So that means that we're telling the court, we cannot solve the problem ourselves. We want somebody else to solve it for us.
Correct.
So it just clouds the process, and that judge is going to be following the case all along.
Correct.
And you're better not to be remembered by the court for the judge not to know who you are as opposed to know who you are because you pissed the judge off.
Yes, and fortunately in South Florida, in my experience, which has been a lot in front of the judges, they do have a lot of patience. So if you're wearing that judge's patience down, you are going above and beyond in some way. Because the judges, especially in the divorce arena, they understand that this is extremely emotional, and they make allowances in every hearing for the occasional emotional outburst or frustration that happens, maybe something that's said that's inappropriate, but it's because someone was emotional. They're they give a lot of grace. So when you're talking about something where you're antagonizing the judge, you have exhausted their grace, and they're very good here about giving people that leeway, and then they still have to manage their courtroom, because someone who's going above and beyond is really actually creating a terrible experience for everyone and not allowing the case to move forward.
Yeah, that's a great point. Another situation that I've run into is that, and I know people are very busy and technology now is very accessible to us through our phones, but sometimes people, out of convenience or perhaps because they're running to a different appointment, they show up through Zoom calls with the judge with a hearing from their cars. I don't think it's a good idea. It just gives the wrong impression.
Absolutely, especially because if you're in a hearing, you want that judge to understand that this is an important issue for you. You don't want them to have the impression that you could care less, because that's actually not a good impression to leave. And it's dangerous. So if you're sitting in your car and you're parked and you say, this is the only place I could log in because I'm at work, that's one thing. But I have also seen people who are driving around.
Yes.
And that is, not only is it discombobulating for everybody who is on Zoom looking at that particular screen, but it's dangerous. And that means you have a distracted driver who is perhaps looking down at their phone to see what's going on, or, and not paying attention to what's going on around them. And I've had judges in hearings say, you need to pull over or we're going to reschedule your hearing. So I don't think that's a good idea on a number of levels, but especially because it does give a certain message to the court that maybe you're not intending.
Correct, especially you're the ones that are filing for divorce in the first place.
Yeah, you're asking for their help. Show up.
and bring the importance that really deserves.
Yes.
It is your case. It is for you. The attorneys, everybody's there trying to help you, but you also got to help the attorney.
Right.
Another situation that happens, and again, the business partnership disputes are very similar to the extent to a divorce proceeding, because there's basically two people that are trying to break up a relationship.
Yep.
As well. When they don't tell you everything, I have situations that...
I love that situation. I love being surprised in the middle of a hearing about facts that I wished I'd known beforehand.
So in a prior episode, I said, tell us everything. We can handle it. If by the time that you call us, it's because something went wrong along the way, whether it's something you did, something somebody else did to you. But we rather have the bad news tell to us at the beginning, because we can figure out a way to handle the bad news, as opposed to finding it from opposing counsel or finding it, through a deposition. Can you tell us a little more about that, how important it is to tell you the good, the bad, and the ugly?
Absolutely. So that is probably one of the number one things I say to a potential client when I'm in a consultation with them, because our job as attorneys is to protect them. And if they are hiding facts for us, and especially, and I say this, especially if they think it is a bad fact, it may in fact be a bad fact, or maybe it doesn't matter. But I want to know so that I don't say something inappropriate, I don't take us down a legal argument that I can't sustain, or the best is I don't want to be surprised in a hearing and look like an idiot. And I don't mean to look like an idiot for me, the attorney. I mean look like an idiot for my client, because clearly that's information they should have shared with me as the attorney, and I could have perhaps protected them from that either claim or that circumstance. Or if it's something that needs to come out, sometimes it's better to fall on the sword and say, yes, Judge, we have this bad fact. We are going to admit it, and we're going to tell you what we're doing to mitigate it. And sometimes that's just the best course of action. Hiding it might be a legal strategy, but it rarely is, because discovery is so broad and so general. And basically in Florida, they say there's no trial by ambush. So unless you have an attorney on the other side that's not paying attention, a smart attorney is going to figure out where the weaknesses are in your case. And so it's better to know that right up front and allow the attorney to strategize with you to minimize the impact.
Eventually it's going to come out.
Always it comes out.
Yeah, and I hear, and even if something, I hear sometimes, I didn't tell you this, I didn't think that was important.
Right.
And I'm like, I wish you would have told me that beforehand. Just even if you don't believe it is important, just share it. just share the information, especially in answering interrogatories, and we'll talk about that, in terms of discovery, interrogatories, production requests, and requests for admissions. It's important for them to really spend some time answering those questions truthfully and thoroughly, because it's not only for their benefit, it's also for our benefit as attorneys.
Correct. And especially in something like an interrogatory, which for our listeners is just really writing an answer to a set of questions that is a sworn statement. So really, the more information you give your attorney with regard to any particular question, they will help tailor that answer. So if you're giving too much information, they will protect you and tell you what information you can omit from, say, a written answer. But you're also giving them background information on your case that they can use down the road or that may be relevant to what's going on at that very moment in your case.
Sometimes clients do not want to share information because it might be embarrassing.
Correct.
I think even if it's embarrassing, just tell us.
Right, because typically it's not our first rodeo for that circumstance. And there's so many, I don't want to say typical, but things happen. People get cheated on, people gamble, people have substance abuse issues. And of course, I'm talking about, big archetype problems that I see in divorce. Businesses don't do well. They have, business issues, or maybe they're not making enough money and their business is going under. All of these types of things happen. And we have strategies for that. We can lead you to the right people to help you. And so the more we know, the better off you are.
That's a phenomenal point. How important it is for the clients to communicate with you, especially in a divorce proceeding?
It's extremely important. Number one, because then I can understand the parameters of what we're working at. What are my defenses? What are my claims? What can I do here? What do I need to be aware of? What do I need to advise my client on if there is an issue? And what kind of professionals can I bring to them so that they can get the help that they need? So, for example, let's say they have children and one of those children has been diagnosed as autistic or is on the spectrum, but one spouse is refusing to accept it and doesn't want to, get that child help. Part of that information coming to me is I can refer that family to the right professionals so that that child can get help. And that is the same thing for the business. If a spouse comes to me and says, the business is going under, I just want to get my divorce, I don't want to go through this, I want to cut my losses. If they can tell me what's going on, I might be able to say, you need to go see a loan officer, or you need to talk to the SBA. You might qualify for a loan. And so there's other ways that maybe we can salvage the family business that was the sole source of support that may have gone awry because they were having marital problems and they took their eye off the ball. And this is really how they've been supporting their family. So more information is better than less, because there is typically an answer to every problem.
And I think the key is also to have the lines of communication open. If the client is not responsive, if they don't get back to us in a timely fashion, we cannot respond or act upon their case if we don't hear from them.
Well, for sure. And if hearings are set and our client is non-responsive to us and we can't prepare with them, we can't really go forward. And unfortunately, sometimes that results in an attorney having to withdraw. So open lines of communication between the business owner, spouse going through a divorce, and their attorney, or even if it's a breakup of a business partnership, is an extremely important part of that representation, because the business owner must assist in the defense and or resolution of that legal case.
Yeah, you're right about that. I want to shift gears a little bit about solving it. So, they go through divorce filing and discovery. So I'm a big proponent of mediation. And in fact, I believe in early mediation in my cases, because I believe the early mediations will give the client the opportunity to resolve the matter before a lot of legal fees are expended.
Absolutely.
How's the mediation process works in family law, and how often it is done, and just tell us a little more about that.
So mediation is required in every case. So that is always a good thing. And depending on the assets and the facts of the case, whether mediation early on is a good thing or a bad thing. I also think when it comes to divorce or a case like that, you have to look at where each spouse is in their processing of the divorce. One spouse may be ready for it and want an early mediation, and one spouse may just be processing, oh my goodness, I've been asked for a divorce and it's out of left field for them. That spouse is not a good candidate for early mediation because they may not have accepted the fact that this divorce is happening. And so they're not going to be in a position to make any negotiations or resolve anything. So an early mediation in that case might not be warranted. However, there will be a mediation once discovery is concluded and it's time for the mediation to happen. If it's just in the right place temporally, like, what, we've done everything else, we got to do this before we go to a hearing, it will happen. But when you're in a mediation, that's your opportunity to become very creative about how your family is going to be supported going forward and how all of your assets are divided. And I said before, the judge is limited by the law. But in a mediation, you can get as creative as you want. So mediations are great, and I'm going to say 90 to 95% of all divorces resolve in mediation or as a result of mediation. And the amount of cases going to trial is very small. Yeah. It's extremely expensive and oftentimes not warranted.
Yes, I agree. One of the things that I tell the clients about mediation is that you have the control. And in the case that we go to trial, we go to, in terms of court proceedings, the attorneys and the judges have the control. The clients have little control. But in the case of a mediation, the clients are in the driver's seat. We're there to assist. We're there to provide any guidance. But if the case gets settled, it's because the two parties agreed to a settlement.
That's correct. And if they agree to a settlement, they're more likely to follow that agreement. Once there is sort of a resolution imposed by the court, and if it's a resolution that what one party does not like or doesn't agree with, the likelihood of them complying with that resolution is small. And then you will have post-judgment litigation, whether it's enforcing payments of alimony or enforcing the distribution of stocks or funds or a business interest. So the mediation is giving the parties their opportunity to resolve their own problem in a way that they can agree, that they can tolerate. And the way I look at a mediation and what I tell my clients is, if you can live with it and neither one of you is happy, it's a fair deal and it's the right thing.
Yeah, I agree. And also you mentioned the creativity. What I like about mediations is that it's confidential, number one. Mm-hmm. Number two, it is, you can be very creative in how to resolve it. And whatever happens on mediation stays on mediation.
That's correct. It's like Vegas.
Yes. And and you also have client control. You control, and you also have closure. At the end of the day, in the case of a divorce, the parties will get divorced at some point.
Yes.
Either they get divorced sooner if they agree to a settlement, they agree to go to the court and get a matter resolved, or because the judge at some point will divorce them, and the judge will determine how the property is going to divide it, how the asset will divide it.
That's correct.
And I think they're better off if they make a decision how this is going to play out, or you want a judge making a decision for you.
That's correct. And I just want to add one thing to the mediation process that neither one of us has mentioned, is that is the opportunity for the parties to say their piece without saying it in front of a judge, right? So oftentimes people need to be heard, especially when we're talking about a divorce. Things have gone on in that relationship possibly for years. And the mediation process, because of its confidentiality and typically because the parties are in separate rooms and a mediator is either shuttling back and forth between the two conference rooms or is going back and forth between the Zoom breakout rooms, that allows each party in their room to say things without the risk of offending the other party. So they can say their piece. It's sort of a relief or just kind of lets them get rid of whatever they've been carrying around with regard to this particular issue. And I find that they feel better afterwards. So not only do they resolve their divorce issues, but they actually feel better, which is great.
They can move on from this psychological
Correct.
trauma of being in a divorce proceeding or in any type of litigation. It's just not pleasant.
Correct.
And once they get the settlement agreement signed, they can move on, they have closure, and they can begin, going with their lives. Mm-hmm. I haven't had a client tell me that after a mediation is settled, say, I wish I didn't settle and I want to continue the trial. They just don't want to do that.
Right.
And they shouldn't. The reality is we do this for a living is different. We do this every day. But people out there, they do not, being involved in litigation, it's just not pleasant. And if they can avoid it, they're better avoiding it.
Yeah, that's correct. It's very stressful. And then suddenly you have to testify if you're the party. You're going to be on the stand and somebody is going to be cross-examining you, which is never, ever a pleasant experience, ever, ever. I'm going to say it one more time. It is never pleasant. And, I've had clients say to me in mediation where I've said to them, I promise you, once you sign this agreement, you're going to feel better. It's a great deal. And I had a client who we resolved his divorce in mediation, and we kind of parted ways. The divorce was over, and he saw me in the courthouse on a fluke a couple of weeks later, and he ran up to me and gave me a huge hug, and he said, you were right. As soon as I signed that agreement, the next day I felt better. And he was so uncertain in that mediation. Should I sign this? What if I do better in court? He was very uncertain about it. And I had convinced him, and I was worried about having convinced him to sign the deal. And when I got that response from him a couple of weeks later, that's when it just reaffirmed for me that this is the right process for families going through a divorce, especially if they own a company, because their stress ends and their new life begins as soon as that agreement is signed.
Yeah, you're correct about that. A few minutes, I want to talk about collaborative divorces. This is a kind of a new concept. Tell us more about that.
So a collaborative divorce happens when the parties both hire collaboratively trained attorneys and essentially remove the divorce process from the judge. So it shifts the timelines. So typically, if you have a regular divorce that's filed in the circuit court, you have 20 days to file an answer after you're served, and you have 45 days to provide your mandatory disclosure. And essentially, the court is going to look in on the case every once in a while and push it along. If you're using the collaborative process, typically what you're doing is you're removing it from that process and saying, we're going to do it on our own time frame. Maybe it's quicker, maybe it's longer. And essentially, the parties are agreeing to hire someone called a neutral facilitator, who is typically a therapist or someone in the mental health industry, to help run the meetings, reframe the way everybody talks about their requests and things they would like, or their opinions about what's going on in the family or the divorce. And it's a very holistic process for divorce.
Is that a new trend now? More people are using it?
It is a new trend. I like the process. It's very holistic. It is great if you have some complicated parenting issues. It allows the parties to feel much more in control of their process because they are the ones making the decisions. So, for example, in a regular divorce, I say, you need to get these documents to me in the next 30 days so I can work on our discovery response. And in a collaborative divorce, I say, when do you guys want to produce these documents?
So they have some control of the process.
They have a lot more control over the process, and there can be a lot more creative within the process. So they may want to have several full team meetings, and maybe there's 4 of them, and at each meeting there is an agenda that talks about the issues that we're going to resolve. Some people might want to do that in one big long meeting. Other people might want to do that in 4 or 5 smaller meetings. So it really does give them control over their divorce.
Okay, great. Where are you located at?
So I'm on Commercial and Federal Highway in Fort Lauderdale. So if anyone is looking to find me, I can be found there. My office number I can be reached at is 954-981-2200. And my website is neavefamilylaw.com. And look me up. I'm happy to speak to you if you have any questions about divorce, or if you own a business and you're contemplating a divorce, or your spouse has said to you they want a divorce. I'm happy to give you some advice and point you in the right direction.
Which areas do you practice in terms of Florida?
So I practice in South Florida. I have cases in Palm Beach County, Broward County, and Miami-Dade County. I do have one in Orlando. I don't typically do that now that Zoom is becoming a thing of the past and in-person hearings are a thing of the present again. I try to stick to the Tri-County area, but I have been known to go to the West Coast and to Orlando. Okay.
Angela, thank you very much for joining us. I'm very excited you're my first guest.
Well, thank you for having me. I was delighted to be here, and what a great book that you have. I read it, and I've referred it out to several people, and I think you've got great advice for business owners.
Thank you, Angela. I appreciate it. Just before I close, how to talk about Business SOS again. Put it here. Put it up on the screen so you can see it. Getting great reviews in the book is a business reference guide for business owners. Actually, I give it to my clients, and I like to invite you to participate in the show. So my challenge to you is this. If you send me a question, and a legal question, any issue that you might have, if I select that issue, I will change your name. I'm not going to tell you, talk about you specifically. I will send you an autographed copy of my book. So how you can do that? You can send me an email at richsierra.com. If you're interested in learning about the services that we provide in my law firm, it's floridasmallbusinesslegalcenter.com. At Facebook, we're at FSB Legal. We also have a YouTube channel. Not only we have the podcast that you're listening to right now, but we also have the video as well. And it's youtube.com at Richard Sierra. And Twitter, I'm at Rich_Sierra. We also have an Instagram page at FSB Legal. You can also call us at 866-842-5202. Remember, Business SOS, 8 common legal mistakes business owner makes and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. If you like the show, please follow us on Apple Podcasts, Spotify, wherever you enjoy the shows. If you like it, please give me a review. That will help. Also, this will be shared with other business owners, and they might be a benefit from the information. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.